No, is it a requirement?
Yes.
No, no.
Okay.
Yeah, so like, where would you be though?
Right there. The screen.
Under the desk? I think you're overthinking just a little.
I do that all the time.
I mean, 3 months from now, you might have a fan club and they might really want to know where you are. But right now, I think we're probably okay.
Hope I don't have a fan club. It's scary.
It's tough. All right. Yeah. Are we ready to go or?
I don't think I sent this document to Laura, so I can run downstairs and send it up or make a paper copy. I thought I had.
That would be if she had that, then would post it on our,
Yeah.
on our
Yeah.
page, okay.
Back in a
Okay.
few minutes.
Political fan clubs want to love you to death.
So what we're, when Mike is back, he's gonna lead us through for the next hour or so, just a summary of the bills that this committee passed out last session, last two years, actually. And there are, I think he said 14 of them. So it'll be a fairly quick walkthrough at a fairly high level, but it'll give us just, a little bit of context to think about the things that we don't need to do because they already happened, or things that actually may have involved, and I'm not certain about this at all, but may in some cases have involved study groups or work groups that were looking at something that could result in a report at some point. It'll come back to us and then possibly require next steps. So we'll do that. And what's on, for those of you who are wondering what this is, if you go onto the legislative site, you can go back and look at previous sessions. And by toggling over there on the left where it says 21-22 change, you can look back quite a while. I'm not sure how far back. So this is the committee page from last time around, and you can see some names there that aren't familiar necessarily or aren't part of the committee anymore or aren't part of the legislature anymore. And then you can, at the very bottom, you'll see that it's sort of cut off and it says bills in and out of committee in green. And you can click on there and see a list of what we're going to be walking through in a few minutes. So, and you can go back and see that for any time period. We're also going to have, when Mike gets back, I think the reason he went briefly out of the room was so that he could send to Laura a document that he's going to be sharing with us that does summarize all of that information. So she will then post that on, step in if I've got any of this wrong, on our webpage. And that will be a sort of resource, an ongoing resource for us is our webpage where when witnesses are in and they've got something that they want to share with us, we will post it ahead of time. And then when we're in committee, feel free to use your iPad, your phone, or whatever, your laptop to pull up off of our webpage, the webpage, those documents. We'll try not to have 11 copies of documents printed, but if anybody would prefer to have a paper copy of anything, that's fine too. I used to do that. I took notes on everything, and I'm not doing that anymore. I've resolved. But if you're not at that point yet, just ask and we'll get you a paper copy.
All right.
Good. So we'll turn it over.
So good afternoon. This is Mike O'Grady. I'm Office of Legislative Counsel. I've been the ag attorney for about 12 years. I'm going to talk to you a little bit about the ag acts that you passed, this committee passed, last year. And I'm gonna stand up to do this. So some of these bills I drafted, some of them I did not. The first one you're looking at right here is Act 43 of 2021. I did not. This relates to how agricultural land gets enrolled in use value. Does everyone know what use value is? It's that property tax program that lowers the tax rate of land that's in agricultural or forestry production, because that's what it should be taxed for, its use and not its market value. All other land is taxed at its highest best use, which is essentially its market value. Ag and forestry land is not taxed at its market value, it's taxed at its use value. And so that's what this did. And what the issue with ag land and use value for a while was you have to certify every year that you're going to remain in the program and that you still meet the requirements for ag land. And farmers were missing it because it happened in September when you were supposed to submit your certification. And that's a busy time. And so they were missing it. And so what the General Assembly did is they amended the requirement that says, hey, if you fail to put in your certification, it doesn't mean you automatically get kicked out of the program. The Commissioner of Taxes has the ability to determine that you're still in the program if you're demonstrating eligibility. So that was very helpful to farmers, especially in September. They also amended the definition of development. Development is what gets you kicked out of use value. If you develop your farmland, or if you develop your forestry land, that's when you get kicked out. When you get kicked out, you get assessed a tax. And so one of the things that it says, development is to allow the land underlying solar arrays to stay in current use program if the solar array is located on a total 1/10 of an acre of land or less. So previously, the Commissioner of Taxes had said if you put a solar array on your farm, that's development, and that land is no longer in use value. Even though you could pasture your sheep under it, you could still use it for ag land. They said, no, that is not, well, the General Assembly changed that and said land underneath some solar arrays is not development, it's still in use value. So farmers can have solar arrays without triggering a tax on that land. So moving down, one of the things that this committee did was to enact Act number 31 of 2021, an act relating to limiting liability for agritourism. Agritourism are those kind of activities that are attendant to farming, attendant to your farm. You bring someone onto your farm to see how farming occurs, to attend a recreational event, attend a celebratory event like a wedding. Maybe you have a farm stay. Maybe you're doing a kids camp. They're all agritourism as it's defined. And what the issue is, the liability of the farmer when they bring people onto their farm, because there are parts of a farm that are dangerous and can pose a risk of injury to people. So what the General Assembly did is it says when a person comes onto a farm, if the farm has properly warned that person of the inherent risk of being on a farm, then the farmer's not going to be liable for that injury unless the farmer is negligent or did so intentionally, has actual knowledge of the dangerous condition, commits an act, error, or omission that constitutes willful or wanton misconduct. So as long as that farmer properly posts the notice of inherent risk and or gives that person participating a liability waiver, they are not going to be liable for an injury that's caused from something that occurs during an agritourism activity. This is very common in most other states. So Vermont basically came up to the national standard for agritourism when they adopted this. The next one is relating to the sale of unpasteurized raw milk. This committee has jurisdiction over basically all things dairy. And there's the conventional dairy operations that are regulated by the PMO, the Pasteurized Milk Ordinance, which is a federal regulatory standard. But when you're not selling under the PMO, you can sell raw milk in Vermont if you meet certain standards. And the standards have relaxed over the past 10 to 12 years as it's become more of a common product where, because when it was first enacted, there was concern that there was going to be significant health issues created by the sale and ingestion of raw milk. That hasn't happened. And so what the General Assembly has done is it's relaxed the standards around raw milk and the sale of raw milk. There's 2 tiers of raw milk producers, the lower tier and the higher tier. Tier 2, you have to meet certain additional requirements. This Act number 22, 2021 allowed the tier 2 producer to sell milk off their farm. Previously, you had to sell milk on your farm. The person had to come to your farm ostensibly so they could see the potential health risk of what was going on your farm and make the decision whether or not they wanted to buy the raw milk. Now that's going away. It allows for sale off your farm. It allows for sale at farm stands. It allows for sale at CSAs that meet specific requirements. It basically relaxed the sale for the tier 2 producer, who again is that person that's meeting the additional standards anyway.
Mike, can I just interrupt? I'm not seeing anything that suggests there was, so I guess there wasn't, but any kind of follow-up or look at how effective these new pieces of statute were from the safety standpoint?
Well, there are reporting requirements for tier 1 and tier 2 producers. They're supposed to report monthly, I think. And they report to the agency. The agency keeps close track of raw milk producers. Agency and the raw milk producers have a somewhat tension-filled dynamic. And so there is reporting. The agency does have data on it. There isn't an agency report on raw milk, though. But you could get it from E.B. Flory, who's the head of the dairy division. One of the things that your committee and the Senate committee traditionally does is they have a miscellaneous agricultural subjects bill each year. These bills normally include what the agency has recommended be adopted or enacted. And so it's kind of a mishmash. Have you gotten an overview from the agency yet of their different divisions?
That's coming up later this week.
Okay. So these bills have recommendations from each of the divisions in the agency. So it has changes to the weights and measures provisions, like how they were going to assess fees on scales, because the agency does inspection and licensing of scale. It repealed the sunset of on-farm personal slaughter. This is a bit of a historical issue, but underneath federal law, you cannot slaughter an animal on your farm and sell it to someone unless it has been inspected by a state or USDA licensed inspector. Unless you're slaughtering that animal for your own use or for the use and enjoyment of your family and your non-paying tenants or guests. All right, so people were slaughtering goats and other animals and selling them, and the agency raised issues, and they raised issues because of something called the Equal To program. Vermont gets a lot of money from USDA for running a slaughter program that is equal to the USDA program. And it's co-beneficial for USDA and Vermont because USDA doesn't have to send as many inspectors up here that they do in states that aren't equal to states. And Vermont gets money to pay for its slaughter inspection division, which they believe is more efficient and beneficial for the regulated community. But if you don't meet the equal to status, you lose your money, Vermont loses its inspectors, there's less inspection, less movement of the product and commerce. So I knew a guy in DC who was Deputy Secretary of Ag called Phil Durfler, great guy. And Phil and I worked out a way around the personal slaughter provision that a person can come to your farm, they can buy the animal from you, they can slaughter the animal on the farm by themselves, or they can hire what's called a custom slaughterer, somebody that's hiring out their slaughtering services, as long as they do so in sanitary conditions and meet some other standards. And the farmer gets to sell up to a set number of animals that way. And it worked great. It was working really well. And so you repealed you had to put a sunset on it to see how it would work. And you took the sunset off when it was starting to work well. Well, Phil left USDA. And there's this guy in Iowa now that doesn't like this. And so he's been raising some issues, and we've been trying to lay low a little bit, but just be aware that you might hear about on-farm slaughter putting the state's equal to status at risk because this guy in Iowa, Keith, doesn't like it. And by the way, like all of these like inspired Wyoming and Maine and other states to enact things, and they did it wrong and got in trouble. And so that's kind of what's hanging out there is we don't want to wind up where Wyoming wound up when they messed up how they did. Another thing that this does is it extends the authorized operation of the payment for ecosystem services and soil health working group. That group's been ongoing for about 3 years now. It was supposed to report back, actually it was supposed to report back 2 years ago, but it's actually been working effectively and the agency has asked for additional time. What this is going to recommend are ways to incentivize farmers to do more effective, environmentally beneficial farming practices such as regenerative agriculture. To give them payments, to create programs, incentives. That's what the Payment for Ecosystem Services Working Group is supposed to do. This ties in to the Climate Council Action Plan, because part of what the Climate Council Action Plan recommended are effectively payment for ecosystem services. So if you can get some sort of quantification of carbon sequestration on a farm, additional practices to filter water, there's potential here depending on what they're going to recommend, and they're going to recommend something this February about what you can do to not only incentivize these practices, but meet the Climate Action Council plan.
So the February 1st date is looming. Did you say that the agency was interested in extending it even further, or is it?
No, this was the extension. I don't think you're going to get the Senator Stars can get a little stubborn about extension of deadlines, and he wasn't too happy about that one, but he extended it. I don't think you're going to see an extension again. This is an animal cruelty bill. I did not draft this one. Bryn Hare, who's now currently the executive director of the Cannabis Control Board, drafted this one. For years, I mean, like 25 years, there was a question of who was a humane officer that could enforce animal welfare requirements and could go onto a person's property to enforce animal welfare requirements, because there was an ambiguity in the criminal law about that. And what 421 does, it says that a humane officer, somebody that conducts animal cruelty investigations, has to be a certain type of law enforcement, a designated humane society employee, or an animal control officer that has specialized animal cruelty investigation training. You had people like showing up on other person's property, knocking on the door saying, I'm a humane officer, let me go inspect your animals. And people are like, who are you? You're Sue, you live down the street, right? And people, it was confusing, but the confusion was because of the statute. And then it requires some training to be developed for those designated humane officers. The next one is H49 of 2021. The Agency of Agriculture is granted in statute the sole authority to regulate pesticides in the state, although some people disagree with me. It actually says sole authority. And their regulatory authority, their ability to adopt rules regarding pesticides, is contingent on them consulting with a body of experts. And that body of experts used to be called the Pesticide Advisory Council. But in 2021, there kept on being these issues, like innovative issues about agriculture, about incentivizing practices for different things, for climate action, for carbon sequestration, for genetically engineered seeds. So the Pesticide Advisory Council was transformed into the Ag Innovation Board. So it's not just about reviewing pesticide rules and pesticide practices in the state. It's now about all these innovative practices that are becoming popular, or at least part of the discussion in agriculture. And they will look at those practices and they're going to recommend to the General Assembly on an ongoing basis practices to implement for the innovation of agriculture. At the same time, they still have to review all of the agency's attempts to change or amend or adopt new pesticide regulations. This is what I call the chicken and compost bill. Everyone knows that food residuals need to be composted in the state. And there were farmers that were working with sources of food residuals to bring those food residuals onto their farm, to use those food residuals either for chicken feed or for composting and selling of that composted product. The problem is you can't bring food residuals onto your farm for feed unless it meets certain US FDA standards, including potentially heat treatment of it to eliminate any of the pathogens. And then the secondary problem is if you're bringing food residuals onto your farm to create a compost product and it's not 50% principally produced on the farm, that 50% of that compost isn't from, or the ingredients aren't from your farm, then that's not farming anymore. That's a solid waste management activity. And farmers were like, wait a minute, universal recycling, you want us to take care of this stuff, but as soon as we take care of this stuff, we're gonna lose our designation as farming, and we lose potentially our use value, we'll lose our Act 250 exemption, we'll lose our municipal land use exemption. And so, and this took a long time, it took years to get to this point. What the General Assembly did is you enacted an exemption to Act 250 from the definition of farming. The Act 250 definition of farming is the regulatory definition of farming that kind of overlaps all the other definitions of farming in statute. And there are 19 other definitions of farming in statute. And so the Act 250 definition is like the regulatory definition. It's what's used in the RAPs to determine whether or not you're farming or not. So we said that when you're bringing in a certain amount of food residuals onto your farm and you're gonna basically use it on your farm or your poultry farm, you're still farming. You don't lose all of the regulatory benefits of farming. And so that's the chicken and compost part. The secondary part of this bill is that there are these products that are being sold that are basically like sold as stimulants for animals. Like one of them is called Kickin' Chicken. It's a supplement that you feed your chicken to make them grow faster. And so the agency wasn't regulating those, so you were getting Kickin' Chicken and honestly drugs that weren't really drugs. They were kind of like, you know, get your ginseng for your donkey thing. And so the agency were like, we really don't know what they are. We need to start registering them and regulating them. And that's what the second part of the chicken and compost bill did. It started regulating those feed supplements and biostimulants. The agency takes a registration fee. The agency takes a registration fee for a lot of things. Pesticides, commercial feed, dog food. A lot of things they register and regulate and they get a fee for that. And that's a large part of the agency's budget, those registration fees. So when you're talking about changing the registration fees, it changes the agency's budget. Universal school meals, I did not draft this one, although I've worked on universal meals in the past. It created a 1-year program to provide free breakfast and lunch to all public school students. I believe that was extended, John, was that extended? Somebody told me it was just extended, that they found more money to extend it for another 6 months.
I think it goes through I think that this put through the end of the school year.
Yeah.
I think that's as far as it goes.
But I think it had been estimated to cost up to $60 million, and it's coming in around 20 million right now. And so there's a discussion about whether or not to extend it. It's been popular. Apparently the participation in school meals has increased by 17 to 25%, some number like that. You take away the stigma from kids, especially in small schools, participating in subsidized lunch programs. I mean, my kid he doesn't even know, he's just like, I just go in line. We all just get in line. Nobody knows who or what. The next is regulating licensed small cannabis cultivation as farming. When cannabis was legalized, there was a significant debate about whether or not cannabis cultivation was farming and whether or not it would receive all the regulatory benefits of farming, whether or not it was going to be use value compliant or eligible, whether or not it was going to be exempt from Act 250, whether it's going to be exempt from municipal, whether it was going to not be subject to different water quality and other environmental standards because it was farming. The chair of House Natural and the chair of House Ways and Means were not real excited about regulating cannabis cultivation as farming. So it was specifically stated that it was not farming and that it was going to be subject to all the other regulatory requirements that things that aren't farming are subject to. Well, the small cultivators were really upset by that. They basically thought that took away a revenue source for small farms that need to diversify in order to survive. And so what the General Assembly did was it allows for the small cultivators, it's like 500 square feet, to be considered farming and to not lose their farming regulatory benefits just because they're a small cannabis cultivator. Next one, this is really a miscellaneous bill. Senator Starr will do that. He'll like introduce a miscellaneous bill and then he'll introduce another bill that really should be entitled miscellaneous bill too. But he calls it something else. And that's because he likes the game. I'm just being really honest, and people have been here now, like at the end of the session, he likes to have as much stuff moving as possible so that he can get things onto his bills that are going to pass. And so this was one of those, it was miscellaneous bill two. A lot of it dealt with water quality, changing how the Agency of Ag does its water quality grants. So the Agency of Agriculture regulates agricultural water quality, but it also finances agricultural water quality management. And they get a lot of their money from USDA, and USDA has a bunch of standards in order for those money to be put out. The state has to cost share that USDA money, but the Agency of Ag, through statute, has about 5 or 6 different ag water quality funding programs. And so last year they tried to basically loosen some of the eligibility requirements and get rid of some of the obsolete practices that were allegedly being funded, but nobody was actually applying for. And so that's what most of Act number 162 did. It basically loosened up some of the water quality eligibility requirements. But then the big thing that it did, and you're going to hear about this. So the state has a right to farm law. And a right to farm law, every state in the country has a right to farm law, I think, except like Rhode Island. But what it does is it says that a farm is protected from nuisance suits and in some states from trespass suits if the farm is meeting certain conditions set in statute. Now, there's a whole prism of right to farm laws out there, going from very stringent Oregon. In Oregon, if your farm is located in an agricultural district, nobody can sue you for nuisance or for trespass unless you kill someone or you ruin a neighbor's crop. That is like, you get to do what you want to do in that agricultural district unless you kill someone or you ruin their crop. And the example of that was they were helicopter spraying pesticides. And it was windy and the helicopter got blown off course and dusted like an entire neighborhood of residential homes twice. The courts are like, that's agriculture. The farm's in an agricultural district. It's not a nuisance. It's not a trespass. So, the concern with Vermont's right to farm law is that it's viewed by many, especially farmers, as being too lax, as not being protective enough of the farm as it could be. And that issue came to a head last year in a case, it's called Erie Farms versus Vorstevelt Farms. And it occurred in Addison County in Panton. Vorstevelts are a fairly significantly sized dairy farm. They do a lot of innovative practices. They bought a bunch of land next to them and they were converting some of that land. They were putting in tile drainage. Does everyone know what tile drainage is? It's effectively tubing in a field to help drain that field of water so that it's more easily cultivated. They did that. They were working with UVM to do all of that. But one of the things that happened, well, there were 2 main actions at issue. One was the smell. They were changed their manure management practices. They were putting more manure on different fields, and it smelled. And some of the neighbors were new to Vermont and didn't like that. And the other thing that they did is that when they tile drained, they had their tile drains draining to where their tile drains had always drained to, but there was more flow coming out of those drains. And what that did is it created scouring, and the ditch it flowed through crossed over a neighbor's property, and it basically blew out the ditch on the neighbor's property so that they couldn't, at times of high flow, even cross the property because of the flow that was coming out from the Borstevelds farm. Judge Teachout, Mary Teachout, said that they didn't receive the protection from the right to farm law. First of all, because the right to farm law only protects against nuisance suits, and that flow and its scouring was actually a trespass. And so Vermont's right to farm law doesn't protect trespass, whereas other states do. And then she also said that it was a nuisance. She said, yes, your application is a conventional farming practice, but there's a provision in the Vermont right to farm law that says if it creates a significant, and I'm not going to get this right, significant adverse effect on your health and welfare, then the farm no longer gets the nuisance protection. And she said the smell from the manure and their application practices was a significant adverse effect on one of the neighbors, and therefore it didn't qualify for nuisance protection. Farmers are not happy there.
What act is that again? What act number is that?
162/2022. They do not like this. They want to be treated like other states, or at least maybe not Oregon, but something more protective. They want trespass protection. They argue that they're doing all these additional water quality measures in order to meet the state water quality initiative. They're doing more. They consider that they do more on a regulatory basis than any other farm state in the country. And they don't get the same or even a similar protection from suits than others do. Now, the response to that is, and this is, and I'm not criticizing anyone, the people that have, the group that has largely opposed the amendment to the right to farm law are the trial attorneys, because they're arguing, well, there's really not that many issues. This is like the first issue that's really come to a head in a while. And then the second thing they're arguing is you're taking away remedies from people that are hurt or harmed potentially by the actions of the farm. If you don't do it right, if you're too broad in your protection, you might be harming other people with this protection. And they argue that that's inequitable. And so that's kind of the tension. The farmers are saying, hey, we're doing all this stuff and we're not being protected. We should be protected like other farming states. Trial attorneys are saying, hey, it really doesn't happen that often where you're going to get sued. And even if you are, well, maybe the person should have a remedy that's injured. And our current right to, they argue the current right to farm law gives them that remedy if it's that substantial imminent effect on public health and welfare.
Excuse me, Mike. Dave, can I ask you to twist that a little bit so the sun's not?
This happens sometimes when
Is that better? Lower it as well?
Maybe go the other direction, actually. I don't think you need to lower it.
Okay.
Yeah.
Oh, that's much better.
Thank you.
Yeah.
It's burning my eyes.
Okay. This was not a committee bill of yours. It was a committee bill of what was then known as House Natural Resources. And until last year, Vermont did not substantially regulate or monitor surface water withdrawals unless it was for public drinking water. So if you were withdrawing surface water for road construction, for farming, for dairy processing, and for your pool, any surface water was not being monitored unless it was being taken into a public water drinking system.
Questions? Does surface water include streams?
That's a great question. It depends on which law you're looking at. Because under the groundwater law, a stream is groundwater. So if you're going to withdraw from a stream that reaches the surface, where it reaches the surface, that's groundwater. But under this law, it's also groundwater. It's also surface water.
It's 100 yards downstream from where it's
Basically, what they came to, there was debate about that, and they reached a consensus change. But yes, under this, it would be a surface water. So what this bill does is it requires A&R to just collect information, right? No permit, just requires people that are withdrawing water, surface water, to report on it. People that are not farmers report to A&R. People that are farmers report to the Agency of Agriculture. And then the act gives A&R the ability to adopt a rule that will in the future potentially require a permit for certain surface water withdrawal. A&R's point when they came forward, there was a study group that worked up this proposal. They're like, we don't even know what's being withdrawn, by whom, at what volume. We need to figure out that before we adopt a permit program. And so that's what they've done. And you'll hear people ultimately when they're gonna adopt that rule saying that 10,000 gallons is too low. And it really depends on what the use is for, because when you look around at other states, the thresholds vary from like 10,000 gallons a day to 600,000 gallons a day. So there's going to be debate about that threshold.
What's the accuracy of reporting if there's no permit and no enforceability?
Great question. When originally introduced, the surface water people withdrawing were supposed to use meters at every withdrawal point. And the farmers were like, are you kidding? That is expensive. I move my withdrawal point around depending on the field that I'm irrigating and the time of year. And so what the farmers proposed is that they keep logs. And that the argument was that a farmer needs to know how much water they're putting on their crop because they can't flood it, and they can't basically drought it. So that was for the farmers. They get to do a log and report. Other people are supposed to have meters. So. So you get another miscellaneous agricultural subjects bill. One of the big one out of this one from 709 from 2022 is accessory on-farm businesses. Have you all heard of this?
Yes.
It's efforts by farms to diversify with businesses that aren't necessarily identified with farming. A restaurant, a distillery, a brewery. And whether or not when they implement that business, it's exempt from Act 250 or municipal land use. This committee did a lot of work on that like 3 or 4 years ago and came up with the standards for it. But municipalities have been arguing that it's hard to implement, and then farms are arguing that it's not it's not doing what it was supposed to do. It's not allowing them to do as much business, accessory business on their farms as they wanted to do. There's a report that's coming back. I just saw some of the potential language. If you take this up, you're gonna have, it's gonna be a little contentious. Because it's pushing, it's further limiting municipal regulation of what happens on a farm. And some people like that and some people don't. And the other one here is FSMA. This hasn't really risen to a head yet, but about 8 years ago, USDA adopted a rule called the Food Safety Modernization Act. And it sets standards for the processing, the cultivation and processing of certain produce on a farm. For example, if you grow lettuce and you're gonna sell it in a package, you've gotta triple dip it in order to meet some of FSMA's requirements, depending on how much you are selling. And so the state generally implements US FDA rules through the Department of Health. And the Agency of Agriculture said, do you really want the Department of Health on farms, or do you want the Agency of Agriculture on farms? So what the General Assembly did is they gave the Agency of Agriculture the ability to enforce FSMA on farms for produce cultivations. And that's pretty much it. The rest of these are kind of technical things around some of the programs.
Great. Thank you for walking through that. Do you have time for a few questions, if there are any?
Yep.
I don't know if there are any.
One of the things I wanted to show you, I told the chair I would show you, is on your website, when you get a bill assigned to your committee, there's this tab right here that says Bills in and out of committee. You click on that and everything that came in, you'll see. And so right now I'm showing the in committee, but then you'll see out of committee. And this shows everything that the committee voted out last year and whether or not it became an act. And you'll see it became an act if it has an act number over here. So that's a great way to kind of track where your bill is. You can see whether it's in committee, you can see whether it's been voted out. You can then follow it to here, like I'll show you. Follow it to the other committee, other chamber. Oh, that didn't work. But there's a way to follow it to the other chamber. So the website is a great resource. I would recommend you spend a little time playing with it. Yeah, the arrows, that shows you how the bill progresses, and then down here at the status page, it shows you exactly where the bill was or is. And it shows you votes on it, amendments on it, when it's signed by the governor, et cetera. There's a ton of information on the website. It takes some time though to figure out where it all is and how to manage it.
Great. We were having a little conversation earlier, and you might not be the best person to have the conversation with, so say so. But just wanted to get a better understanding of, deadlines for submitting bills, and then what options there are if that deadline comes and goes. So this is in the context, we were talking about committee bills. And it may be as simple as that if you miss that deadline. There is such a thing as a committee bill. I don't know if you have any other information you can share on that.
Sure, I just need to find the rule. All right. No member may introduce a bill in the House in standard form unless they submit the request to Ledge Council on or before the last legislative day of January, and then approves the bill for public release on or before the fourth legislative day before the end of February. So basically, until the end of January for an individual member to request a bill, and almost the end of February to request to submit it for printing. Then for committees, in the first year of the biennium, a committee may submit a request for a bill to be drafted in standard form at any time and may introduce such bill at any time. That's the first year. And the second year, you have until the last legislative day of March.
Okay.
And what about amendments, there's germane rules as far as those sort of miscellaneous housekeeping bills?
That's a question that's often subject to debate, especially among the House clerk and the Senate secretary about what is germane or not. The House is a little bit more forgiving about germaneness, and effectively, if it's added into a bill during the committee process, prior to the committee's report to the body, it's usually found to be germane. The Senate does not do the same thing. The Senate secretary will look at the substance of what goes into the bill and say the bill says it's an act related to miscellaneous agricultural subjects, but you've added something in there that addresses solid waste law. He'll say, no, that's not germane. Not in the same title, not in the same subject matter. It needs to be removed. So it can be a bit of a judgment call. The clerk and the secretary recommend to the presiding officer, and the presiding officer can do what they want. There used to be a speaker who would just do what he wanted. Clerk would recommend something and he's like, no, it's germane. But then the speaker can be subject to a challenge as well. I've only seen that done twice, and it never works out well.
First to the right. Yeah. Great. Well, we will sort all that out, and good to have that background. Thank you. Any last chance for questions?
I've got a quick one, Attorney O'Grady, regarding, let's see, Act 162 of 2022. This was the impact on neighbors' farm activity. Was that a toughening of the protections for the farm or a loosening of the protections for the farmer?
It's neither. What 162 did is it didn't change the standard, so the standard stayed where it was. What it did, it changed the scope of the activities that were protected. It clarified what was farming for the purpose of the protection under the existing standard.
Primarily based on the precedent that you cited with that one judge teach out?
No, what I did for that is the bill that was originally introduced was kind of a combination of the Arkansas and Michigan right to farm law. And those two states basically had the same listing of activities that were protected. And it was arguable that they were protected in Vermont, but it was also arguable that they were not. Instead of letting the courts have that decision, it was put into statute about what received protection. But the standard doesn't change. The standard is still arguably one of the least restrictive in the country.
So if my farm stunk and my neighbors wanted to sue, am I protected?
Not necessarily.
Not necessarily, okay. That's good. Got it.
All right, well, thank you. Committee, I think we're done for today then, and tomorrow we're getting back